Oklahoma is set to execute an inmate on death row in 1 week, despite the state's parole board expressing doubts about his guilt. Julius Jones was 19 years old when he was convicted in the 1999 murder of Paul Howell. Jones and his family have argued that he is innocent. Last week, Oklahoma's Pardon and Parole Board recommended clemency for Jones. His fate is now in the hand of Governor Kevin Stitt, who will make the final decision ahead of Jones's planned November 18th execution. Amanda Bass is a federal public defender in Arizona and is one of Julius Jones's attorneys. She joins me now for more. Amanda, tell us about Julius Jones and why the Pardon and Parole Board believes that he should not face execution next week.
Thank you for having me. Julius was 19 years old when he was arrested and prosecuted for the 1999 shooting death of Mr. Paul Howell. He was represented at his trial by 3 attorneys, none of whom had ever handled a death penalty case before, did no pretrial investigation, did not interview a single state witness before they got on the stand and testified, and presented no evidence whatsoever in Julius's defense. So unsurprisingly, he was convicted and sentenced to death, and the jury was deprived of compelling evidence that would have objectively established his innocence.
Now, I need to say that the family of Paul Howell firmly believes that the right man is being held responsible for his murder. Since taking over this case, tell us what your team has discovered in terms of new evidence that points to your client's innocence.
Well, importantly, the jury did not have a photograph of Julius taken just a few days before the shooting that would have objectively proved that he did not fit the only eyewitness description of the shooter. The co-defendant, however, did fit that description. The jury didn't hear the testimony of Julius's mother, father, sister, and brother, who were all adamant that Julius was at home with them during the time that Mr. Howell was tragically shot and killed. And the jury also never heard the testimony, the sworn statements of 4, now 5 individuals who have since come forward to state that the co-defendant bragged about committing this murder and blaming Julius for what he, in fact, had done in order to avoid the death penalty. And so that evidence, in addition to thousands of other pages of documents that we put before the Pardon and Parole Board through the commutation and clemency process, is really the foundation of their 2 recommendations that Julius's death sentence be commuted.
So let me underscore that point. He had an alibi at the time. His description did not match that of the description of by the eyewitness, and that there was another person who bragged about actually having committed the murder. There's another part of it too, racism. There are claims from one of the jurors who was on that jury, who said that racism, in fact, played a role in how Mr. Jones's case turned out. Tell us more about that.
That's exactly right. In 2019, we learned from someone who'd served on Julius's jury that during the trial, she overheard another juror refer to Julius using the N-word, claimed that the trial was a waste of time, and believed that Julius should be immediately taken out back behind the courthouse, shot, and buried for what he had done. We tried to get back into court with that evidence to establish that Julius did not receive a fair trial and his sentence was tainted by racial prejudice, and unfortunately were procedurally barred from presenting that information to a court, but were able to put that before the Pardon and Parole Board.
Now, obviously, Amanda, you represent Julius Jones. You believe in your client's innocence, but you aren't the only one. The parole board actually feels like there is enough doubt that he ought not be executed, and they made that recommendation. Now it lies in the hands of the governor. So what are the next steps for you and the rest of the legal team if the governor decides not to take up that clemency recommendation from the parole board?
We are hopeful that Governor Stitt, looking at all of the information that we put before the board, that founded the board's 2 recommendations to commute Julius's sentence, will do the right thing and intervene to prevent a miscarriage of justice here. But if that does not happen, I think we'll just need to evaluate our options at that point. I can't say what those would be.
And if I understand it correctly, if the governor follows a recommendation, it isn't that Mr. Jones would be released, it's that he would be spared execution next week. Is that correct?
The governor could decide to accept the recommendation of the Pardon and Parole Board, which would give Julius the opportunity to seek release. That recommendation was life with the possibility of parole. But the governor also has the option to commute to life with parole, or to a term of years, or to whatever he sees appropriate.
One last question for you. How do you think that your client's case and its outcome reflects on the justice system as a whole?
Well, I think Julius's case really exemplifies the ways in which the adversarial testing process, which our system relies on to produce just outcomes, did not work. And I think it underscores the importance of the clemency process as part of our constitutional and statutory framework to act as a fail-safe to prevent miscarriages of justice in situations where the evidence is so clear that the system broke down.
Amanda Bass, thank you so much for joining me.
Thank you for having me.